North Carolina government has seen a recent flurry of activity linked to the state constitution and the separation of powers among the governor, the General Assembly, and the courts. One of the people who has watched these issues with great interest is John Dinan, professor in the Department of Politics and International Affairs at Wake Forest University. Thanks for joining us.
Good to be here.
So I would imagine that before 2017, not that many people in North Carolina were really paying a whole lot of attention to the Constitution and what it says about who controls what, who has the most power in state government. But this has really been in the headlines day after day after day this year, hasn't it?
I mean, I often, when I go to talk to groups, particularly about state constitutions, and I ask the members of the groups, how many of you had a chance to look at your state constitution and read your state constitution? Not surprising, this number is usually pretty low. But I'm gathering that as I asked that question in 2017, there's going to be some numbers, some more hands that are going to be raised in the audience of people who are going to have a reason to look at their state constitution, precisely because we now have a Republican-controlled legislature and a Democratic-controlled governor, and those things are just set up for conflicts, and many of those conflicts will be based on constitutional principles and will oftentimes be resolved in courts that have to interpret constitutional provisions.
Now, for those who haven't really followed this closely or don't remember much from their civics classes, the Constitution really does spell out, doesn't it, who controls what and who has the most power.
Yeah. I mean, we're most of us are very familiar with the U.S. Constitution. We've seen the general pattern of it. And state constitutions really follow in some ways the main provisions of the U.S. Constitution, in that there's a Bill of Rights. There are provisions setting out here's how you elect the legislature, here's how long the governor serves, here's how long the Supreme Court justices serve. And then there's a few policy provisions. That's the one thing that's a little bit different from state constitutions to the federal constitution. The federal constitution has very few so-called policy provisions, and you find a few more of those in state constitutions. Not so many in the North Carolina Constitution as you would say in California or Colorado, some of these others. But other than that, though, state constitutions serve some of the same purposes as the federal Constitution does of organizing the government, limiting power, and securing rights.
Throughout the history of this state, when you look at the legislature versus the governor versus the courts, for years and years and years, the legislature really has been the dominant branch, hasn't it, in North Carolina?
Yeah. And there's various indications of that. One is for the first half century, the legislature selected the governor, and that was not unusual for American states, but it wasn't until the 1830s that actually the governor was independently elected by the people. The other thing, and this is the most striking thing, the North Carolina governor did not have the power to veto legislation until 1996 is when that was granted. That was a number of decades after every single other state in the country had granted their governor the veto power. That means the North Carolina governor for the last 20 years only has exercised the veto power and still lacks what is known as the line item veto power. That is the ability to veto particular items in bills. North Carolina is one of only 6 states that deprives its governor of that power. I could go on and provide other examples, but these are just illustrations of the way in which the legislature has clearly been the dominant branch in North Carolina that's set out in the Constitution, and that's illustrated in a number of ways.
We're speaking with Professor John Dinan of Wake Forest University. Fast forwarding now to the present, it looks as if after the election of Roy Cooper as governor in November, many members of the General Assembly and their top advisors took a look at the state constitution to see if there were ways that they could get the legislature even more power in this battle between the two branches. Is that right?
That is right, and there's one that got a lot of high-profile attention but never came to fruition, and that is the North Carolina Constitution does not set a fixed number of Supreme Court justices. It just so happens that there's 7 Supreme Court justices now, but actually the state constitution is quite explicit that if the legislature so chooses, it could raise that number to as much as 9. And so in the immediate aftermath of the November 2016 election, so there was some discussion about whether or not the North Carolina legislature would exercise its constitutional power. It ultimately decided not to do that, but it did take a number of other steps in a December 2016 special session. Those included, in one case, exercising powers that had always been in the state constitution but had laid dormant. And the leading example of that is the North Carolina state constitution is quite explicit that the governor shall, with the advise and consent of the Senate, make appointments unless these appointments are already provided for in the Constitution. That's for the Secretary of State, the various kind of council of state offices. And that had not actually been exercised by previous legislatures. And the legislature in December 2016 said, we're going to start exercising that power and going to start requiring that the governor shall receive the advise and consent of his cabinet appointments.
as we're speaking, that whole issue of the cabinet appointments is still in flux, and the courts have not ruled on this. But this is going to be an interesting debate about whether the Constitution, as it's written, will end up holding firm and winning out in the final determination of things, or whether Roy Cooper can win the day by saying, look, this has never happened before. This would be such a departure from our past that this is just political gamesmanship and the court should throw it out.
Yeah. There are several different types of matters that are going to be coming before the courts. There's, on the one hand, this matter concerning Senate confirmation of gubernatorial cabinet appointments. That is about as clear as one gets in terms of constitutional text, as that is permitting that to be done. There are, though, some other conflicts, at least two other conflicts. One is concerning the relative powers of the superintendent of schools versus the State Board of Education, and then a second conflict concerning how many people will there be on the state and local election boards, and will the governor's party still have the advantage, as his party has always had the advantage in the past, or will there be an even distribution of 4 members on the state election board of the governor's party and 4 of the party out of power. Those other measures, that is concerning the composition of election boards and concerning the state superintendent's power relative to the state election board, those are not explicit in the Constitution. Put another way, there's a lot of interpretation that can be offered about exactly what is the power of the governor here, what is the power of the legislature. That would be distinguished, though, from the case concerning the ability of the Senate to require confirmation of gubernatorial cabinet appointments, which is quite explicit in the text of the Constitution that that's permitted. That would be distinguished from some of the other cases where one can have arguments on both sides. And all this comes down to take things to kind of the next point, is that how should we interpret a state Supreme Court decision issued in January of 2016, the McCrory v. Berger decision, and aptly named. It's not quite a Bush v. Gore type of name, but it's about as close as we get in North Carolina, McCrory v. Berger, which involved a particular case of could the legislature set up a commission, an executive commission, and then could they appoint a majority of the members of that commission. And this was not explicitly resolved by the Constitution, but by a decision by the North Carolina Supreme Court with only one dissenting justice. The court decided that the background principles of separation of powers gave enough ability to the governor that he must be able to carry out executive duties. And in this particular respect, the legislature had taken away and transgressed on the governor's executive power. What we're going to see in a number of cases in 2017 is how to interpret those provisions that were given in McCrory v. Berger, the January 2016 decision, to these other cases. A lot will rest on how the court reads that 2016 decision.
Our time is running very short, but do you think one upside of all of these debates is that more people will pay attention to the Constitution and its role in North Carolina government?
I've oftentimes raised the flag at various efforts to try to kind of wave the flag and say, look, state constitutions, they don't get anywhere near the attention the U.S. Constitution does, and yet they're important in their own rights. They grant rights sometimes that are in addition to the rights that you're granted under the U.S. Constitution. They, of course, set up all kinds of institutions that are different from the U.S. Constitution. So if one consequence of some of these recent court decisions is to turn people and interest people in the state constitution, that would be a good thing.